Good evening, Mr. Speaker. Good evening, ladies and gentlemen. Ladies and gentlemen, Iowa Code Section 2.56 requires, under law, that prior to debate on the floor of a chamber of the General Assembly, a correctional impact statement shall be attached to any bill, joint resolution, or amendment which proposes a change in the law which creates a new crime or significantly changes the scope or impact of an existing crime or increases the penalty associated with a crime. These correctional impact statements, in addition to containing information about the cost to the state of prosecuting and otherwise enforcing these new penalties, it also includes information about the impact of the new crime or the increase in the penalty on Iowa's minority population. I think these are very important statements for us to review and give consideration to before we vote on any legislation that greatly or even at all increases a penalty or creates a new crime. It's information, it's relevant, and it does impact our constituents. So I think that's why I wasn't there when they passed this law, but I assume that's why they did pass this law. Now, Senate File 342 does not have any correctional impact. It didn't create a crime. It didn't increase any penalties. So there was no correctional impact statement filed on Senate File 42. However, the amendment before us creates new penalties, new crimes, and it increases the penalties substantially in some cases for crimes that are already in existence, and it increases the scope of crimes that are already in existence. And deliberately or not, a lot of those new crimes and increased penalties are going to have a greater impact on that segment of our population that feels it is necessary for them to protest in order to attempt to protect their rights than on other segments of the population. So the point is that since there is no correctional statement filed on this amendment, and so by debating this amendment now, and I presumably by voting, I assume the amendment will pass, and ultimately the bill as amended will become law, I am seriously concerned that because we are in violation of state law, not House Chamber rules or policy, but in violation of state law, that by debating this bill without waiting for the correctional statement that I have now requested when I realized during caucus that there wasn't one on this amendment, that we will be jeopardizing the integrity of all of the various provisions of this bill, of all of the crimes created by this bill, of all of the benefits to law enforcement created by this bill. So will Representative Klein yield, please?
Will the gentleman yield?
Yes, I will.
You're in order.
Thank you, Representative Klein. So as I talked to you before, like just a few minutes before, and told you that I had not realized that there wasn't a correctional statement associated with your amendment until we looked at it in caucus, because this came out of a committee that I'm not on, and it's a bill that I'm not involved in, and brought this to your attention. And I guess having had this law that mandates a correctional statement be filed on any amendment that creates new crimes, as this does, I guess I'm asking you, would you be willing to defer further debate on this amendment until such time, and it might be tonight, I'm sure it would be tomorrow at the latest, that we do have the correctional impact statement, which will also provide us with the minority impact statement of the changes proposed in your amendment?
I appreciate your concerns, but at this time, I don't believe we should be doing that. I think we ought to go further into that chapter section and go down to number 6. And at the bottom, it says, however, requests for revised correctional impact statements shall not delay action on a bill, joint resolution, or amendment unless so ordered by the presiding officer of the chamber. So I think we're well within the law as I read the code. But thank you for bringing it to our attention.
Sure, and thank you for that response. As you know, I'm not requesting a revised correctional statement because there wasn't a correctional statement filed on this bill. I'm requesting an original correctional statement, and as it states in the first paragraph, it is illegal to debate and vote on a bill, on an amendment, not a revised amendment, but on an amendment that there has not been a correctional statement prepared for and attached to the amendment when it creates new crimes. So, I mean, I appreciate your interpretation of that. And if I was asking for a revised correctional statement based on the adoption of an amendment to a bill that already had a correctional statement on it, and if I was saying, well, I think now this amendment we just adopted is going to change the correctional statement already filed on the bill, then I would agree. I think at that point the speaker would be entirely within the law to say, no, we're in the middle of debate, we're just going to go ahead, and he would not be violating the law. I think just the black letter of the law that this chamber passed many years ago makes it clear that you need a correctional impact statement on an amendment that changes the law. So, I mean, I guess you're taking a position, you disagree. I assume your leadership disagrees. I hope for the sake of our law enforcement that you're correct, and that going forward without the mandatory information that we are required to have before us when we consider amendments like this, I hope that does not ultimately, at some point in the future, invalidate the provisions of this bill. So, thank you.